Chief Justice Rehnquist, distinguished panelists and guests, ladies and gentlemen, I'm Bill Cooper, President of the University of Richmond. On behalf of our law school and the Bar Association of the City of Richmond, I want to welcome you to this symposium on the independence of the judiciary, honoring Senior Justice Harvie L. Carrico. Let me also remind you to please turn off any cell phones at this time. I know business is being done as we speak, but this is worthy of our attention. My colleagues and I are pleased that this timely and important conference is being held right here on our campus. Too often we take judicial independence for granted. It is essential to the preservation of freedom and the rule of law, but it is also vulnerable to the pressures of the political process. We want judges who are principled and courageous, yet we also demand that they are ultimately accountable to the people. The tension between judicial autonomy and accountability will be a prominent theme throughout the symposium, and we look forward to hearing speakers' views on this subject. The symposium also gives us an opportunity to thank one of the greatest jurists in Virginia history, Senior Justice Harvie L. Carrico, who served on the Supreme Court of Virginia for 42 years, including 22 years as Chief Justice. Besides being a giant in the legal profession, Justice Carrico has been a terrific friend of our law school and a wonderful model for our students. At the conclusion of this afternoon's program, the Dean of the Law School, John Pagan, and members of Justice Carrico's family will unveil a portrait that we commissioned in his honor. I would now like to turn the program over to Judge J. Harvie Wilkinson of the U.S. Court of Appeals for the Fourth Circuit, who will introduce our keynote speaker. Judge Wilkinson.
Welcome all. I think all of us are mighty pleased to be here at this fine law school and this fine university, and all of us are deeply grateful as well for the stewardship of Chief Justice Harvie Carrico. And there really can be no greater tribute to Harry than the presence here today of the Chief Justice of the United States. The biography of Chief Justice Rehnquist can be found on innumerable websites. And I wish to emphasize briefly why he is a special leader of the federal judiciary who ranks among the greatest chief justices in American history. It would be easy enough amidst all the deference shown a chief justice to believe that you are the Lord High Excellency of the universe. And the Chief Justice has had the wisdom to resist all of that. He carries himself in a modest and unpretentious manner. He has demonstrated that great responsibility requires even greater humility. And his self-effacing manner over time has won him the entire country's respect. The Chief Justice is really the judiciary's Renaissance man. He is a scholar with a penchant for timely subjects, and has written books on impeachment and civil liberties during wartime. When he was called upon to preside over an actual impeachment proceeding during his own term, he did so with the dignity and the impartiality that made all of us in the federal judiciary proud. The Chief Justice has transformed the way Americans regard their Constitution. He has emphasized its importance as a structural document, and his opinions have generated seminal insights on the relationship of the federal courts to the executive, to the Congress, and to the states. But when I said the Chief was a Renaissance man, I was not thinking only of his intellectual gifts. He is a tennis player who does not like his partner to poach at the net. And he is a master of American popular music of all varieties. His rendition of Clementine and Anchors Away are now legendary staples of the Fourth Circuit's annual sing-along. are two special moments which I would like to recall. The very august figure before us today was not always such, and the Chief has written engagingly of his efforts to win a clerkship with Justice Robert Jackson, one of the greatest justices to sit on the Supreme Court. And I thought I would read you two paragraphs of the Chief's own description of his interview. This may be especially interesting to those of you University of Richmond Law School students who have a clerkship of one sort or another in mind. Well, here are the Chief's own words. It cannot be difficult to imagine the fear and trembling with which I approached the interview. My academic record at Stanford Law School was excellent, but Stanford at that time did not enjoy as much national prestige as it now does. I first tried to bone up from my meeting with the justice by reading some of his opinions and by trying to steep myself in constitutional law. After a few hours, however, I decided that it was utterly futile. If I had not learned enough constitutional law in my course on the subject to qualify for the position, I probably would not learn it in a few additional hours of cramming. I met with Justice Jackson in one of the faculty offices, and his pleasant and easygoing demeanor at once put me at ease. After a few general questions about my background and legal education, he asked me whether my last name was Swedish. When I told him that it was, he began to reminisce about some of the Swedish clients he had had while practicing law in upstate New York before he had moved to Washington. I genuinely enjoyed listening to the anecdotes, but somehow I felt I should be doing more to make a favorable impression on him. He, however, seemed quite willing to end the interview with a courteous thanks for my having come by, and I walked out of the room sure that in the first minutes of our visit, he had written me off as a total loss. Well, of course, Justice Jackson did not write off the Chief as a total loss, and the rest is history. And there is another delightful moment of that history that also bears recalling. Last year at our Judicial Conference meeting in Washington, the Chief recalled for us some of his experiences as a sergeant in the United States Army Air Corps in the latter part of World War II. And after the Chief's lecture, we were shown a huge picture of some young GIs on a beach in Tunisia. And they were obviously having a great time and waiting to return home. We were asked to pick out which one of these young men was the future Chief Justice of the United States. That can't be him, he's too handsome, one of us said. It wasn't me that said that. But indeed, the handsome GI was him. And that picture, I think, served to underscore for all of us the fact that the Chief's life has been throughout one of devoted and selfless service in so many capacities to his country. We're truly blessed to have a leader of his stature and his humanity. It is a great honor for me to introduce this wonderful American to all of you today.
Thank you very much. As my late colleague Bill Brennan would have said, my father would have loved that introduction, and my mother would have believed it. This afternoon, I am delighted to participate in the University of Richmond Law School Symposium on Judicial Independence. The symposium is being held, as Jay said, in honor of Chief Justice Harry Carrico, who has served 42 years on the Supreme Court of Virginia. 22 as Chief Justice, and I'm pleased to join all of you on this occasion, recognizing his long and distinguished career. Judicial independence is one of the touchstones of our constitutional system of government. I like to think that the belief in the wisdom of an independent judiciary is not confined to judges alone, but is shared by other members of the legal profession and by the public at large. It is easy today to see the need for an independent judiciary, with the authority to enforce the terms of a written constitution. But back in 1787, when the Founding Fathers were drafting our Constitution, it was an entirely novel concept. I think that the creation of an independent constitutional court with the authority to declare unconstitutional laws passed by the state or federal legislatures is probably the most significant contribution the United States has made to the art of government. The importance of judicial independence is illustrated very well by comparing our experience with the Bill of Rights and the French experience with the Declaration of the Rights of Man. The Bill of Rights was ratified in 1791. The French Declaration of Rights 2 years earlier in 1789. In comparing the language of the French Declaration of Rights of Man with the Bill of Rights of the United States Constitution, one would say that while there were certainly some differences, the basic guarantees provided by each were pretty much the same. But when we turn from the catalog of rights contained in the French Declaration to what actually happened in France in the few years following 1789, we find a dramatic difference between theory and practice. With only a few years of the adoption of the Declaration of Rights of Man, a regime known as the Reign of Terror began. During this period of time, 300,000 persons were imprisoned, about 20,000 people went to their deaths on the guillotine, and another 20,000 died in the prisons or were executed without any trials. One history of the French Revolution has described the Reign of Terror as judicial murder. A revolutionary tribunal was created to try any political offense. According to one scholar, the Revolutionary Tribunal functioned like a court-martial, inflicting only one penalty, death, with no recourse possible against its sentence. Little attention was given to the separation of the judicial authority from the legislative and executive powers. The chief legislative body was the National Convention. The convention created the Revolutionary Tribunal, and during its brief existence frequently altered the size and composition to suit political ends. Judges and jurors on the tribunal were appointed and removed by the convention. The convention wrote the laws, frequently initiated the prosecutions, and effectively controlled the courts. All this happened in a country which only a few years before had adopted the Declaration of the Rights of Man and of the Citizens. It seems to me that the reason it happened was that during the Reign of Terror, there was no institution that could actually uphold the rights contained in the Declaration. The legislature was supreme, it promulgated the laws, it authorized the prosecutions, and it controlled the courts. It really didn't make any difference that all of the fine sentiments contained in the Declaration were still formally in effect, because there was no independent organ of government in France at the time, which could stand up and enforce them on behalf of the individual. In contrast to the French experience, the American scheme included an independent judiciary, separate from the legislature and the executive, and with power of judicial review. Article 3 confers upon the judiciary life tenure during good behavior and contains a prohibition against diminution of compensation while in office. Article 3 judges can only be removed from office through the mechanism of impeachment, and having the security of their positions, their salaries, goes a long way towards ensuring judges' independence. But how do we get from independence on paper to independence in practice? It has not been a smooth ride, and several times, 3 times in our history, there have been significant challenges to the independence of the federal courts from the political branches. The first of these confrontations occurred very early in the 19th century, shortly after Thomas Jefferson's Republican Party had succeeded in seizing control of both the presidency in the Congress from the Federalists as a result of the election of 1800. Historians have called it the Second American Revolution, in which the Republicans led by Jefferson and Madison captured both the executive and legislative branch of the federal government from the Federalists, who had controlled them during the first 12 years of the new nation. The Federalists were determined to strike one last blow at their Republican enemies before losing control of the executive and legislative branches on March 4, 1801. John Adams remained president until then, and the lame duck Congress was controlled by Federalists. So the Congress passed the Judiciary Act of 1801, which in calmer times would have been judged to be a significant measure of judicial reform. It abolished the circuit-riding duties of the Supreme Court justices and created a number of new offices as lower federal court judges. But to the Jeffersonian Republicans, and from their perspective, it was a transparent Federalist patronage scheme. It was said that John Adams stayed up until midnight in his last days in office signing commissions to the new judicial positions, and those judges were henceforth referred to as the Midnight Judges. So when the Republicans came to power in 1801, they set aside to undo the work of the lame duck Federalists. Since the Constitution provided for the removal of federal judges only by the process of impeachment, the Republicans looked around for a suitable target and settled on a man named John Pickering, a rather hapless, mentally deranged, and frequently intoxicated federal district judge in New Hampshire. Obviously, he was not a model of judicial propriety. There was no question that Pickering was a disgrace to the judiciary and should have resigned. But were mental derangement and chronic intoxication the sort of, quote, high crimes and misdemeanors that the Constitution requires for impeachment? In March 1803, the House of Representatives impeached Pickering, and almost exactly a year later, the Senate voted to convict him and remove him from office. The Senate vote on Pickering's impeachment did not augur well for the independence of the judiciary. The vote in the Senate was strictly along party lines, with all of the Republicans voting guilty and all of the Federalists voting not guilty. The very day that the Senate voted to convict Pickering, the House of Representatives voted articles of impeachment against Justice Samuel Chase of the Supreme Court of the United States. This second impeachment proceeding was portentous with consequences. Chase was one of the 6 members of the Supreme Court. He was a Federalist appointed to that position by George Washington in 1796. If Chase were to be removed by the same party line of vote as Pickering was, the federal judiciary, and particularly the Supreme Court of the United States, would almost certainly be relegated to a junior status among the 3 branches of the federal government. And it was said, though not completely convincingly, that had the impeachment of Chase succeeded, the Republicans would then have gone after John Marshall, who was the Chief Justice. So Thomas Jefferson, when he heard in May 1803 of a charge which Justice Samuel Chase had given to a grand jury in Baltimore, denouncing some of the Republican policies, he was quick to write to Joseph Nicholson, one of the Republican leaders in the House of Representatives. He said, "Ought this seditious and official act on the principles of our Constitution and on the proceedings of a state go unpunished? As to whom so pointedly as yourself will the public look for the necessary measures? I ask these questions. For myself, it is better that I should not interfere." Now, I realize that in Richmond, Virginia, one hesitates a great deal before criticizing Thomas Jefferson. The only place you'd hesitate longer is in Charlottesville. But here, Jefferson was something of a skulker. Let's face it. I mean, he wanted things done, but he wanted other people to do them for him. The House of Representatives first investigated possible charges against Chase and then voted to impeach him. The articles of impeachment, including not merely Chase's charge to the Baltimore grand jury, but also charges that he had shown a high degree of partiality in presiding over the trial of a man named John Fries in Philadelphia and of James Callender in Richmond during the year 1800. Fries had been the leader of an uprising called Fries's Rebellion, which farmers in northeastern Pennsylvania had risen up against federal tax assessors and prevented them from carrying out their duties. Today, Fries probably would have been charged with obstruction of justice, but at that time he was charged with treason, tried before Chase, and sentenced to hang. John Adams, to his great credit and against the unanimous advice of his cabinet, pardoned Fries. Here in Richmond, James Thomas Callender was tried under the hated Sedition Act of 1798, which was aimed at repressing political opposition. Callender, a well-educated Scotsman, notorious hack writer, and great drinker, was indicted for publishing a book entitled The Prospect Before Us, in which he was said that he brought President Adams into disrepute by accusing him of being a monarchist and a toady to British interests. Callender was fined $200 and sentenced to 9 months in the Richmond jail for libel. As it turned out, he later met with an unhappy ending. Not because of his writing, though. He drank too much whiskey before taking his daily bath in the river and was drowned. When Samuel Chase's trial before the Senate opened on February 4, 1805, in the new capital of Washington, D.C., interest naturally focused on the principals in the forthcoming drama. The Vice President of the United States, presiding officer in the forthcoming drama, and in the Senate was Aaron Burr. Burr was a dapper man with piercing black eyes. Even as he sat as the presiding officer of the impeachment court, he himself was a fugitive from justice. During the preceding summer in Weehawken, New Jersey, Burr had killed Alexander Hamilton in a duel. Indictments against him for murder in New Jersey and a lesser offense in New York were outstanding, leading one wag to remark that although in most courts the murderer was arraigned before the judge, in this court the judge was arraigned before the murderer. Samuel Chase, who stood to lose his office as an associate justice if convicted by the Senate, was more than 6 feet tall and correspondingly broad. His complexion was brownish red, earning him the name Old Bacon Face. not of course, to his person. He was hearty, gruff, and sarcastic. One would rather have had him as a dinner companion than as a judge in one's case. He had had a distinguished career. He was Chief Justice of Maryland, been at the Constitutional Convention, and he was a very bright man, but very determined in his view. Joseph Story described him as the living image of Samuel Johnson, in person, in manner, in unwieldy strength, in severity of reproof, and real tenderness of heart, and above all, in intellect. Chase's principal counsel defending him against the charges was his longtime friend Luther Martin. Luther Martin from Maryland was one of the great lawyers in American history, and also one of the great iconoclasts of the American bar. He was the first Attorney General of Maryland, served in that office for more than 20 years. He was a member of the Continental Congress, member of the Constitutional Convention. Like James Callender, he had a marked weakness for the bottle, but at least in the short run, intoxication did not seem to impair his performance in court. He was described by the American historian Henry Adams as the rollicking, witty, audacious Attorney General of Maryland, drunken, generous, slovenly, grand bulldog of federalism, the notorious reprobate genius. The last of the rarae aves in this cast of characters, which assembled for the trial of Samuel Chase, was the principal manager for the House of Representatives, John Randolph of Roanoke. He had been elected to Congress from his Virginia district while still in his 20s, and became, in effect, the administration's leader in the House of Representatives. William Plumer described Randolph, not yet 32 at the time of the Chase trial, as a pale, meager, ghostly man who had the appearance of a beardless boy more than a full-grown man. The presentation of evidence before the Senate took 10 full days, and more than 50 witnesses testified. The charges against Chase with respect to the trial of John Fries for treason did not, judged from the perspective of history, amount to much. The charges against him in the Callender trial amounted to a great deal more. And his charge to the Baltimore grand jury was certainly unacceptable today, but in those days, frequently the federal resident judge was the only presence of the national government in a particular area, and they felt themselves perfectly okay to explain what the national government was doing and how great the Sedition Act was, that sort of thing. The closing arguments in the Senate began on February 20th, and in the oral tradition of that time lasted several days. On March 1st, the Senate convened to vote on the counts against Chase. Senator Uriah Tracy of Connecticut was brought in on a stretcher. It was regarded as such an important vote. Since the names of the senators were called individually on each of the 8 counts, roll call took some time. At this time, there were 25 Republicans and 9 Federalists in the Senate, and it was clear that if the senators voted along party lines, the necessary 2/3 vote to convict Chase could be had. The first roll call was on the charges growing out of the Fries trial, and on this count the vote was 16 to convict, 18 to acquit. All 9 Federalist senators voted to acquit, and they were joined by 9 of the 25 Republicans. On the next series of counts growing out of the Callender trial, there was a majority of 18 to 16 to convict, but no 2/3. The final vote was on the charge to the Baltimore grand jury, and on this count the managers came closest to success. 19 senators voted to convict and 15 voted to acquit, still not a 2/3 majority. After the roll call, the Vice President rose and recited the votes on each count, and then recited the portentous words, "It therefore becomes my duty to declare that Samuel Chase is acquittals exhibited by the House of Representatives against him." The significance of the outcome of the Chase trial cannot be overstated. Chase's narrow escape from conviction in the Senate exemplified how close the development of an independent judiciary came to being stifled. Although the Republicans had expounded grandiose theories about impeachment being a method by which the judiciary could be brought into line with prevailing political views, the case against Chase was tried on the basis of specific allegations of judicial conduct. Chase's behavior during the Callender trial was very bad so far as a judge is concerned. And the refusal of 6 Republican senators to vote to convict, even on this count, surely cannot have been intended to condone Chase's acts. Instead, it represented a judgment that impeachment should not be used to remove a judge for conduct in the exercise of his judicial duties. The political precedent set by Chase's acquittal has governed that day to this. A judge's judicial acts may not be the basis for impeachment. The second time in American history in which the independence of the Supreme Court was challenged occurred shortly after the Civil War. 4 years before the Civil War, the court had handed down the decision in the Dred Scott case, which left its image very, very tarnished, at least throughout the North, a feeling that the court had reached out far further than it should to hold the Missouri Compromise unconstitutional. It was rightly referred to by a later Chief Justice as a self-inflicted wound from which it took the court at least a generation to recover. When the North was victorious in the Civil War and the new Republican Party gained control of both houses of Congress, the radical wing of the party did not look kindly on the court. The radical Republicans enacted a series of statutes known as the Reconstruction Acts, which divided the previously seceded states of the South into military districts, with military governors who had authority to override state legislation. The traditional trial by jury was replaced with trial before a military commission. In 1867, a newspaper editor in the southern state of Mississippi, a man named William H. McCardle, used his publication to criticize Reconstruction as well as the military officers administering it throughout the South. His vituperative editorials understandably landed him in hot water with the military, McArdle was arrested, charged with several crimes, including inciting insurrection and printing libelous statements, and he was held for trial by a military tribunal. McArdle sought habeas corpus in the federal court in Mississippi, claiming that his arrest and detention was contrary to the Constitution. The Circuit Court decided against McArdle, and under the law as it then existed, he had an appeal as a matter of right to the Supreme Court of the United States, which he promptly took. Rumors abounded that the Supreme Court would use the McArdle case to declare the Reconstruction Acts unconstitutional, and there is substantial evidence that sentiment on the court favored such an outcome. But in early March 1868, as the case was being argued before the Supreme Court and submitted for decision, Congress swiftly repealed the very legislation which gave the court jurisdiction over the case. The repeal bill became law in late March of 1868, and although the McArdle case had come up for discussion at conference 6 days earlier, the court adjourned on April 6th and ordered the McArdle case to be put over until the next term. In an attempt to force the court to act, attorneys for McArdle had asked that the effect of the repeal legislation on the case be argued before the court, and this request was granted. When the court finally issued its opinion in the following year, it unanimously upheld the repeal measure and dismissed the case for lack of jurisdiction. In an opinion written by Chief Justice Salmon P. Chase, no relation to Samuel Chase, the court held that Article III of the Constitution gives power to Congress to make exceptions to the Supreme Court's appellate jurisdiction, and the court could not inquire into the congressional motive behind the legislation. The prestige of the Supreme Court obviously did not fare well during its encounters with the Reconstruction Congress. Undoubtedly, it could have ruled differently in the McArdle case, but it may well be that the court's apparent decision to live to fight another day was the best conceivable one under the circumstances. Some 60 years had elapsed between the acquittal of Samuel Chase in 1805 and the decision in the McArdle case in 1869. Nearly 70 more years would elapse before the time of the third incident in American history, when the independence of the Supreme Court was again threatened, this time by the President. In 1937, President Franklin Roosevelt was beginning his second term in the White House by virtue of an overwhelming electoral victory in 1936, in which he won the electoral vote of all but 2 states of the Union. The Supreme Court wasn't an issue in the presidential election, but the court was apparently very much on Franklin Roosevelt's mind, because during his first term, the Supreme Court had declared unconstitutional several measures that he had urged Congress to pass, and Congress did pass. Confronted with this series of defeats, FDR decided to take action. In his view, the court had become a roadblock to the progressive reforms needed in the nation. Justice President Jefferson in 1801 had trained his sights on the Federalist members of the Supreme Court. FDR planned to use his immense political resources to bring the court into step with the President and Congress. In February 1937, he summoned members of his cabinet and the Democratic leadership of both houses of Congress to an unusual meeting at the White House. There, he unveiled the message he planned to send to Congress that day, recommending that the judicial branch of the government be, as he put it, reorganized. The message proposed that for each member of the Supreme Court who was over 70 years of age and did not elect to retire, and 6 of the 9 members of the court were in that situation, the President would be empowered to appoint an additional justice to the court, thereby enlarging the court's membership to a total of 15. The true reason for the plan, of course, was to enable the President to pack the court all at once in such a way that New Deal social legislation would no longer be threatened. But FDR based his public argument on the duplicitous premise that the older judges were unable to carry a full share of the court's workload and that the court was falling behind in its work. And this reason was demonstrably false, as would soon be shown. The proposal astounded the Democratic leadership in Congress and the nation as a whole. Political observers thought that Roosevelt would undoubtedly get what he wanted, though. You know, we're used to gridlock in Congress today, the closely divided Senate, a closely divided House. At this time, the Democrats had a 4-to-1 margin in the House of Representatives, and of the 96 members of the Senate, only 16 were Republicans. So whatever the opposite of gridlock was, that situation obtained. The Chief Justice at this time was Charles Evans Hughes. Hughes and the associate justices of the court were offered free broadcast time by the radio networks to speak about the president's plan, which FDR insisted on calling a reorganization plan, while its opponents dubbed it as a court packing plan. The justices wisely declined these offers and said nothing. But Chief Justice Hughes worked busily behind the scenes with Senator Burton Wheeler of Montana, a Democrat who agreed to lead the opposition to the bill. Hughes wrote a letter to Senator Wheeler using very telling statistics to show that the Supreme Court was entirely abreast of its workload and could not possibly decide cases any faster than it was doing. With a briefing schedule typically is going to allow several months between the time review is granted and the time the case is heard. And unless you just want to prevent the lawyers from getting as much time as they ought to have, you just couldn't do any better. This letter, presented to the Senate Judiciary Committee, demolished the original justification for the bill and caused President Roosevelt to switch to a franker defense. The Supreme Court, as presently constituted, was frustrating the popular will by invalidating needed social legislation. Now, FDR was the first president to really master the radio. There wasn't any television in those days. But he said, "My friends, and I'm confident that you are my friends," and would go on to explain in very simple terms, and, you know, the people ate it up. The battle in the Senate lasted from March until July 1937. One event after another damaged the plan's chance for an enactment. That spring, the Supreme Court handed down 2 decisions which upheld, by the narrow vote of 5-4, important pieces of FDR's social legislation. This was thereafter known as the switch in time that saved 9. Next, one of the oldest and most conservative members of the court, Willis Vandevander, retired, giving the president an opportunity to appoint a new member of the court without the need for the court packing plan. Eventually, public opinion began to rally against Roosevelt's proposal. Debate in the Senate on the bill began in early July, in the midst of one of the worst heat waves in Washington history. A few days after the debate began, the Democratic Majority Leader and Floor Leader for the bill, Senator Joe Robinson of Arkansas, was found dead of a heart attack one morning in his apartment. The Senate recessed in order to allow senators to take the train to Little Rock for Robinson's funeral. And so FDR naturally wondered, how has the death of the Majority Leader shifted things in the Senate? So he called in his Vice President, John Nance Garner, known as Cactus Jack Garner. And you couldn't have imagined 2 people who were less alike. Garner was from Uvalde, Texas, and coined the famous statement that the vice presidency wasn't worth a warm bucket of spit. And he was so opposed to FDR's policies that he could never bring himself to call him Mr. President. He referred to him as Captain. So FDR asked Garner to go along on the train and find out how much support there still was for the bill. And after he came back, FDR called Garner in and said, "Well, how do we stand?" And Garner said, "Well, Captain, do you want it with the bark on or the bark off?" FDR said, "Okay, I'll take it with the bark off." Garner said, "You don't have the votes to pass the plan anymore." There were enough contingent votes, people who owed favors to Joe Robinson and were willing to vote because he was the floor leader, but they wouldn't vote once he was dead. Roosevelt realized that he did not have the votes to pass the bill in the Senate, and he agreed on a face-saving solution by which the bill, rather than being defeated in a floor vote, would be recommitted with a tacit understanding that the provisions relating to the Supreme Court would be deleted. Supporters of the court packing plan hope to effectuate this compromise by using such vague language that the casual observer would not realize what was happening. They had almost succeeded when Senator Hiram Johnson, a maverick Republican from the state of California who had opposed the plan, asked the floor leader whether the portion dealing with the Supreme Court was dead. At first, the floor leader tried to shunt the question aside, but the white-haired Californian persisted. "The Supreme Court is out of the bill," demanded Senator Johnson. "The Supreme Court is out of the bill," finally acknowledged the floor leader. Hiram Johnson then exclaimed, "Glory be to God," and sat down. After a momentary pause, as if by prearranged signal, the spectators' galleries broke into applause. The President's court packing plan was indeed dead. Franklin Roosevelt lost the court packing battle, but he won the war for control of the Supreme Court. He won it not by any novel legislation, but by serving in office for more than 12 years and appointing 8 of the 9 justices in the court. In this way, the Constitution provides for ultimate responsibility of the court to the political branches of the government. So 3 times in America's history, a politically dominant majority has challenged the authority and independence of the Supreme Court as an institution. In 1805, it was Samuel Chase. The effort was to remove a member of the court from office because of the content of his rulings from the bench. In 1868, the congressional leadership sought to strip the court of its jurisdiction to consider a particular case because those leaders thought that the Supreme Court would rule against the constitutionality of a measure viewed by them as essential. And in 1937, the President tried to enlarge the size of the court so that he could immediately place 6 of his own appointees on it and swing the ideological balance from conservative to liberal. These incidents are to some extent an outgrowth of the tensions built into our 3 branches of government. To a very significant degree, these tensions are probably desirable and healthy in maintaining the balance of power in our government. Ultimately, we have had the good fortune that through the system of checks and balances, the independence of our Supreme Court and the federal judiciary has been preserved when such conflicts have arisen. We have seen that this in large part is dependent upon the public respect for the judiciary. For it was the United States Senate, a political body if there ever was one, which stepped in and saved the independence of the judiciary, both in the Chase trial in 1805 and Franklin Roosevelt's court packing plan in 1937. I suspect the court will continue to encounter challenges to its independence and authority by the other branches of government because of the design of our constitutional system. The degree to which the independence would be preserved will depend again in some measure on the public's respect for the judiciary. Maintaining that respect and a reservoir of public goodwill without becoming subservient to public opinion will always remain a challenge to the federal judiciary and to any other judiciary too. Thank you very much for the opportunity to speak with you today.
Thank you, Mr. Chief Justice. We'd now like to take a very brief intermission to set up for the next portion of our program, and for security purposes, I'd like to ask you to please stay in your seats. Thank you very much.
First time I've heard you deliver a fascinating history lesson. It's a wonderful gift. Thank you very much. I owe a personal debt to the organizers of this enterprise, a debt of which I'm sure they're unaware. I've been in my present position for more than a decade, and so in the distant past I was dean of a law school, and I am on a bare contractual basis still a professor of law. The fact that I was invited to participate in this role in such a distinguished proceeding with such an eminent group of colleagues gives me hope that there is a belief somewhere that when I finish this present assignment, I'm subject to rehabilitation and restoration to a really important job, which is to be a professor of law. So I thank them for that. And I also want to say that something I think we all know, that we owe a debt of gratitude to those who conceived and organized today's program. The symposium subject, Judicial Independence, compels us to consider what we really mean by the rule of law. The man in whose honor we gather embodies all of those things that make us proud of our judicial system. Harvie Carrico's example defines what we mean by selfless public service. His personal integrity, his professional honor, and his inexhaustible zeal for judicial reform have inspired all of us who are privileged to know him. The sum of his work has left a legacy of judicial statesmanship which places him comfortably among a handful of the truly great Chief Justices in Virginia's history. We're lucky, too, in the distinguished trio who comprise our panel. Kenneth Starr, former judge of the U.S. Court of Appeals and Solicitor General of the United States, is now a partner in the law firm of Kirkland & Ellis. He is, I'm sure, most famously known as the former special counsel in the Watergate matter. That is, everywhere in the country, I think, as I told him, except William and Mary, where he's most famously known as the chair of the Warren E. Burger Library fundraising campaign, which he successfully completed. Jefferson Powell, former Principal Deputy Solicitor General of the United States, is Professor of Law and Divinity at Duke University. Penny White, former Justice of the Tennessee Supreme Court and Professor of Law at the University of Tennessee College of Law. So, those are our panelists, and this is our plan of action. Each of them, beginning with Judge Starr, has the opportunity to make a brief presentation. When each panelist has finished, I will follow up with questions directed to individual panelists, and I'll invite their colleagues to comment on the answer given. We're going to have some fun. It's going to be intellectually stimulating, I know. And I really do, there'll be some very constructive disagreement here. We begin now with Judge Starr.
Thank you. Thank you, President Sullivan, Chief Justice Rehnquist, Chief Justice Carrico, in whose honor we gather, and Mrs. Carrico, Judge Wilkinson, Mr. President, Dean. As we reflect on judicial independence, I want to draw our minds, and I'm mindful of what President Sullivan has said. We are to be brief. Mr. Chief Justice, there's no red light here on the podium, but I will take that admonition to heart. During the debates over ratification of the Constitution, Mr. Madison issued a warning. He issued a warning in the Federalist Papers that there were numerous dangers to balanced government, which is what the architects of the Constitution believed that they had created in the proposed government. But that the attack to balance was most likely to come from the legislative branch. Everywhere, Mr. Madison wrote, that branch is seeking to draw matters into its vortex, what we would simply call today power grabbing. Now, to be sure, as we have seen over the nation's history, part of that history so beautifully canvassed by our Chief Justice, Excesses and abuses have occurred in the Article 2 and even in the Article 3 branches, and thus a free people are ever wise to be vigilant for dangers to balanced government wherever they may arise, in keeping with Dr. Franklin's famous admonition and observation as he left the convention in Philadelphia and responded to the question, what sort of government have you given us? A republic, if you can keep it. And in keeping with that happy occasion that brings us together in honor of Virginia's Chief Justice, let me add modestly to Dr. Franklin's description that ours is a federal republic. This is not France, and I mean no disrespect. That is, and we heard a good deal of French history today. I'm delighted, frankly, to be an American. Ours is not, and was not intended to be, a centralized republic. And this structural truth has been conveyed time and again, but especially over the last decade by our Supreme Court, and I believe wisely so. And so it is that in reflecting on the judicial role and the role of independence, we are well to be reminded of the ever-present danger articulated by Madison, that we are to be watchful of legislative intrusions, legislative attacks, legislative incursions that can have the effect of eroding the bedrock principle of independence of the judiciary. Judicial independence is a large subject. It summons up powerful feelings of the uniqueness of the judicial role. We conjure up in our minds images of Holmesian dissents, sometimes joined by Brandeis, or learned hands' elegant tributes to this feature of a constitutional republic, that judging is not to be politics by simply other means. And this means a struggle within the judicial mind, a continuing one as every judge and former judge knows. The challenge to be self-disciplined, to look for decisional sources, materials that are understood and identifiable, and to treat those materials, including the materials of history, with respect and integrity. These are not necessarily the means or mechanisms of politics, and thus they are removed by structural design from the processes of the political branches. These two worlds, that of the judicial process and law on the one hand, and that of politics and legislating on the other, most visibly clash not only in the exercise of the bedrock power of judicial review, but also in the process of advice and consent. We have come to know it as the confirmation process. I have been asked to reflect briefly on that. What are the rules, if any, to guide this increasingly stormy process? Perhaps more precisely, are there principles that can guide this process when the judicial nominee climbs up that very tall hill called Capitol Hill and enters the confirmation world of the United States Senate? And in view of our reflections this afternoon, what do these principles, if we can identify them, teach us about judicial independence? Let me turn very briefly to the voices of three sitting members of the Supreme Court of the United States. In his confirmation hearings in 1987, Justice Kennedy said this in resisting answering a series of questions. I think if a judge decides a case because he or she is committed to a result, it destroys confidence in the judicial system. Senators and representatives are entirely free to vote for a particular bill because it favors labor or because it favors business. That is the way politics works, and that is your prerogative. To identify such an interest, it seems to me, is being candid. But that is improper for a court. The court must base its decision on principles applicable to all parties. That is inconsistent, in my view, with deciding a case because it reaches a particular result. Or consider Justice Souter's testimony in the early 1990s. Is there anyone who has not at some point made up his mind on some subject and then later found reason to change it or modify it? No one has failed to have that experience. It is much easier to modify an opinion if one has not already stated it convincingly to someone else. Can you, senators, imagine the pressure that would be on a judge who has stated an opinion or seemed to have given a commitment in these circumstances to the Senate of the United States, and for all practical purposes, to the American people? You understand the compromise that that would place upon the judicial capacity, and that is my reason for drawing the line. Or Justice Breyer. Let us imagine if I am lucky and if you find me qualified and vote to confirm me, I will be a member of the Supreme Court. And as a member of that court, I will consider with an open mind the cases that arise in that court, and there is nothing more important to a judge than to have an open mind and to listen carefully to the arguments. I do not want to predict, nor do I want to commit myself on an issue that I feel could come up to the court. There are two reasons. The first reason is how often it is when we express ourselves casually or express ourselves without thorough briefing and thorough thought about a matter that I or some other judge might make a mistake. The other reason, which is equally important, is that it is so important that the lawyers and the clients understand that the judges are open-minded. Now, these are the voices of the judicial perspective in the crucible of confirmation. Confirmation hearings, as we witness from time to time, build in an enormous hydraulic pressure. And historically, as we have heard from these voices, there has been resistance by nominees to answering specific questions. A specific example which I witnessed, that of Justice, then Judge Sandra Day O'Connor in 1981. Less than a decade had passed since the decision in Roe versus Wade. She was pressed by two United States senators to opine on that particular case. And at that time, a very substantial majority in the Senate in both parties agreed that this was unwise. The senators had the power to answer the questions, but it would be better and more prudent to show restraint in the questions being asked, and that Judge O'Connor was wise to be prudent and cautious in not providing an answer. The underlying premise, of course, is that questioning can intrude, even for the best of reasons and motives, into this bedrock value of independence. Years ago, as a very young judge, newly installed, and just learning my way around and beginning to try to learn the judicial craft, I had an observation from a considerably more experienced judge, soon to be the chief judge of the court on which I was privileged to serve for a season. He said, "Ken, you know that you are a judge exercising your constitutional independence when your conscience leads you to vote against the people who appointed you." An interesting test of independence. The controversy suggests the need for judicial modesty and judicial restraint. We see that in various areas because it is these areas that give rise to these issues that become so stormy in confirmation. The attitude of modesty or restraint captured so beautifully in Gerald Gunther's marvelous biography of Learned Hand, the words of Professor Gunther. His stance was modesty. doubting the court's competence to decide the problems of public policy that tend to come before them under our Constitution, worried lest judicial interventions undermine the maturing of democratic processes, the wise use of independence. Was that a failure of will on Learned Hand's part, an unwillingness to live up to the responsibility of judicial review, and not having a more robust attitude toward his role as an independent judge? I don't think so. Perhaps there will be disagreement about that. But it is rather in the highest of our traditions of taking fully into account the supremacy of the Constitution and allowing self-government as a way to protect independence. This is, in short, a vision of ordered and lawful independence, a value that is of immeasurable worth in a constitutional democracy. And perhaps as the confirmation process from time to time seems to spiral downward, it would be useful to be reminded that it has not always been thus, that there have been times, including in the recent past, when the voices of restraint in the process of confirmation have been deeply respected by the world's greatest deliberative body. Thank you.
Thank you very much. Professor Powell.
Mr. Chief Justice Rehnquist, Chief Justice Carrico, it's a great honor to be here today. The topic of judicial independence is, of course, an especially fitting one for us to consider as we gather to honor Chief Justice Carrico's service. I'd like to begin by quoting a citizen of this Commonwealth, one whom we've already heard about from Chief Justice Rehnquist. Thomas Jefferson once wrote that in a free government, judges should not be dependent upon any man or body of men. But Jefferson also wrote, the same Jefferson, that judicial independence of the will of the nation is a solecism, at least in a republican government. I propose that we consider briefly the complexity that Jefferson's comments suggest, that we consider the question of what judicial independence really means and what its purpose or purposes might be. For my text, I turn to words of the great Virginia scholar and judge St. George Tucker, whose 1803 edition of Blackstone's Commentaries was a milestone in the development of American legal thought. Tucker, in discussing judicial independence, traveled over what was by then familiar ground. He repeated various pragmatic points that Blackstone and others had made in describing the value of judicial independence. As Tucker put it, judicial independence is absolutely necessary to enable the courts to make decisions without the hope of pleasing or the fear of offending the legislature or the executive branch. And unlike Blackstone, but like his fellow Americans, Tucker added to these arguments the existence of judicial review as a reason for protecting judicial independence. But Tucker went beyond these arguments to insist that judicial independence in and of itself, beyond pragmatic concerns, beyond judicial review per se, is a value and indeed a specific and vital aspect of the structure of separated governmental powers. Judicial independence, Tucker wrote, stems from the letter of the Constitution which defines and limits the several coordinate branches of the government. The Constitution does so most fundamentally, he said, by securing to each branch the free exercise of its constitutional functions. The vital words here are defines and functions. For Tucker, the courts ought to be independent because by definition what courts do, their function is distinct from the functions of legislatures and executive officers. Judges are independent for the same reason, though not by the same means, that executive officers and legislators are independent, because what each branch does is in some core way distinctive and unique. The reason that a system of imperfectly separated powers is tyrannical by definition is that such a system permits a department of government to carry out a function that it is ill-suited to exercise with a proper sense of responsibility to the people. For Tucker, in other words, judicial independence properly understood is not antithetical to judicial responsibility, as Jefferson had feared. Tucker wrote, "That absolute independence of the judiciary for which we contend is not incompatible with the strictest responsibility, for a judge is no more exempt from such responsibility than any other servant of the people, according to the true principles of the Constitution." Tucker's answer to Jefferson's worry is that judicial independence is the very means of securing the judiciary's responsibility to the people, not a grant of independence from the will of the nation. Judicial independence is the form that Republican principles take when they are applied to the shaping and the activities of the courts. To see how this might be so, I think it will be helpful to distinguish three separate strands in the concept of judicial independence. I'm going to call them three independences, each one of which I believe to be part of our tradition, although the terminology may not be completely familiar. The American legal tradition, I argue, expects and requires that courts possess and act on independence of position, independence of decision, and independence of thought. Only when all three of these independences are present do the courts possess that absolute independence that the founders believed essential to a free and republican constitution. Any serious lapse in the maintenance of any of these three independences, whether by pressure from without the courts or failure within, renders the courts dependent in a fashion inimical to their ordained and vital role in our constitutional system. Let us turn first to that independence which can be most easily described, independence of position. The courts are only truly independent, our tradition has maintained, when the judges hold their positions free of personal worry that a decision obnoxious to the powerful can lead to a loss of position, status, or salary. The function of adjudication involves, by definition, the reality that the judge will cause disappointment from time to time to unhappy litigants, uncomprehending public opinion, and members of the other two branches of government. For this reason, as Hamilton wrote in The Federalist, an independent spirit in the judges must be essential to the faithful performance of so arduous a duty. But magistrates whose positions are in the control of those they may offend can hardly be expected in the long run to disregard the personal consequences of their decisions. Theoretical responsibility to the people's law will give way to de facto subservience to those who cannot claim to be the people even when they represent a momentary popular majority. It is vital, therefore, in devising free and republican constitutional structures of government that the people create such structures, such safeguards for the independence of the courts, as, in Hamilton's words, will foster the firmness, integrity, and moderation of the judicial magistracy. Considerate men of every description, Hamilton went on, ought to prize whatever will tend to beget or fortify that temper in the courts. Only if they possess independence of position can we expect judges truly to be responsible to the people for their execution of their function of impartial and unbiased judgment in individual cases. Independence of position, then, is concerned with tangible external threats to the court's proper exercise of their constitutional function, and it is secured in the founders' view by external structural protections for the individuals who exercise the powers of the courts. The second strand in the weave making up judicial independence is what I am calling independence of decision. The courts are only truly independent, our tradition is maintained, when the decisions of the judges take effect, are enforceable and enforced, without circumvention or defiance by legislatures or executive officers. The function of adjudication involves, by definition, the actual resolution of disputes. Writing in 1800, James Madison sharply distinguished an expression of opinion unaccompanied with any other effect than what it may produce on opinion from the decisions of the courts, which by definition are carried into immediate effect by force and enforce the general will, whilst that will remains unchanged. No matter how carefully and impartially judges interpret the will of the nation expressed in constitutional provisions and statutes, their ability to turn theoretical responsibility to the people into reality will be an illusion if the executive refuses to execute their judgments or the legislature subjects their decisions to review, express or de facto, in some manner. For what avails it, Tucker commented, that an impartial tribunal have decided a case in accordance with the people's law if the other branches of government can ignore the court? Independence of decision, then, is also concerned with an external threat to the execution of the judicial task, but it can only be secured in the end through the living day-to-day.
That means you rule in favor of business, notwithstanding the facts or the law. The business of electing judges in many states has become a financial arms race, with a fallout every bit as disastrous to society as any military arms race. It is a financial arms race to elect judges, where only very few heavy hitters can compete. A statewide industry has a lawsuit headed to the state Supreme Court. They raise almost $300,000. They run a candidate for the Supreme Court against an incumbent. They fly the candidate from appearance to appearance in the industry jet. The candidate wins, both at the polls and the candidate wins at the polls on Election Day, and the industry wins in the Supreme Court on Judgment Day by a vote of 4-3, the deciding vote cast by the new justice. And in the nature of a Louisiana lagniappe, those of you who know that phrase, it means a little something extra, the Supreme Court then authorizes an investigation into plaintiff's counsel, a law school legal clinic, and ultimately alters the rule that allows law students to practice in the court. In another state, a trial judge and his supporters decide to pad his war chest and retire his campaign debt by selling sponsorships to his induction ceremony. That, of course, is the ceremony where the judge takes an oath of office and swears to uphold the Constitution. For a few $1,000s, the donors will be listed as a sponsor of the ceremony or of the judge. It is not just judicial elections and financial atrocities that suggest to me that the pendulum is not at rest. Just 7 days ago, the Commission on the 21st Century Judiciary released a draft report for the National Colloquium on the 21st Judiciary. The headline for the article concerning the draft summarized it in this fashion: Commission warns, state courts at risk. The elaboration on the article was no more subtle, and I'm quoting, "State courts are on the brink of a crisis because of the escalating partisan battles being waged for their control. State courts must be inoculated not only from the toxic effects of money, but also from partisan politics and special interest." Playing partisan politics with the judiciary is a favorite sport. Regardless of the outcome, the public loses when judges feel pressure to rule based on so-called ideology rather than upon the facts. Recent examples include judges being subjected to demeaning personal inquiries under the guise of reviews of their fitness for the bench, questioning a judge's adherence to rarely enforced state morality laws, and investigating judges who have advocated fairness for lesbian parents. And these examples, ladies and gentlemen, hail from Virginia, where judges have assured me of a disciplined process. Those who apply an ideology test for judges make a false assumption that judges can be placed on a continuum ranging from the most liberal to the most conservative based on that judge's personal beliefs. The assumption is false in almost every regard, but one of the greatest falsities is the assumption that judges judge based on personal opinion. As judges know, their personal opinions are irrelevant and have no place whatsoever in determining the applicable law or the evidence. A judge simply cannot reinterpret the law in favor of his or her own personal opinions. While a legislative or executive office holder may be swayed, in fact, probably should be swayed by public opinion, a judge cannot. The outcome of a judicial decision cannot depend on its popularity or even its acceptance. Resisting the pressure to please the majority is the greatest strength, not a weakness, of the judiciary. Those who would tinker with judicial independence may gain a momentary political victory, but they will lose, and they will cause a great and lasting loss to our system of justice and the rule of law. In many states, special interest groups hide under names like Citizens for Independent Courts and Citizens for Fair and Independent Justices. The former is actually a group of labor unions and trial lawyers, the latter an organization of insurance companies and big business. Another group calls itself the United States Senior Associates, but it is actually a group of pharmaceutical companies. While all entities and organizations are entitled to express their preferences, why these organizations assume such misleading community conscience names is a bit confusing. The confusion clears, however, when you do the research and learn that these groups often refuse to register as PACs, decline to report their expenditures, and do not disclose their donors. Recently, special interest groups have become more demanding of candidates. They are demanding in their expectations of sitting judges and of those who seek the office. They demand answers to substantive questions regarding what they call judicial philosophy. After last summer's decision in Republican Party of Minnesota versus White, the groups have become very precise in their explanations, in their expectations. And this is a quote: "Demand to know the judge or candidate's position on the issue that interests you. Hold the judge's feet to the fire. If the judge declines to answer, hiding behind the political skirts of the Code of Judicial Conduct, hold the judge accountable." Accountability, in their jargon, simply means remove the judge from office. Not only has the White decision removed the barrier between judicial office holders and publicly declared viewpoints, it has further blurred the fundamental distinction between judicial office and other elected offices. Judges are now free. In fact, I would suggest many now feel forced to announce their views on disputed legal and political issues. Because, in the words of the decision, if a state chooses to tap the energy and the legitimizing power of the democratic process, it must accord the participants the First Amendment right that attaches to their roles. This assertion ignores the critical distinction in the roles of judges and the roles of other governmental actors. It turns Justice Frankfurter's simple explanation on its head. It all but breaks the pendulum from its stem. In response to White, special interest groups can and will be more demanding. Judges who refuse to announce their views will be targeted for removal or defeat. And quite naturally, to those who equate the judiciary with politics, announcement on their views will be expected to indicate commitment on their issues. Judges who have announced their views before a campaign or during a retention will feel pressured to rule in accordance with their views. Judicial independence will be threatened, therefore, not only by outside political forces, but by judges who abdicate their responsibilities and impose their previously stated views. Since White, other seemingly impenetrable barriers between judging and just politics seem to be crumbling as well. 3 weeks ago, a federal circuit court upheld an invalidation of a judicial ethics rule that disallowed judges from personally soliciting money and endorsements. State court judges in Georgia and presumably throughout the 11th Circuit will now raise money and seek endorsements just like other politicians. Similarly, another federal court in New York has paved the way for judges to participate wholeheartedly in partisan political activities, invalidating another code of judicial conduct provision that previously prohibited that. Both decisions exalt, in my opinion, as did the Supreme Court white majority, the judge's First Amendment rights over his or her constitutional obligations. In the words of one commentator, the decisions make judges politicians who wear black robes. Judicial decisions will be seen as merely political ones, no different from votes by the legislative or orders of the executive. The integrity of the judiciary will be denigrated, and I fear my pendulum will finally break. It was great Virginians who devised the blueprint of an ideal democracy, one with three separate, different, independent branches, one where the politics of governing and the neutrality of judging remained separate, one where judges were insulated from partisanship, special interest, and majority whim. There was another great Virginian, Chief Justice Harry Carrico, who once wrote in praise of Chief Justice John Marshall that Marshall, quote, took a federal judiciary which politicians had sought to make a subservient handmaiden of other branches and gave it the freedom and independence vitally essential to its existence. Justice Carrico said that while James Madison gave the Constitution a body and George Mason gave it a heart, Justice Marshall gave it its soul. I can think of no greater disservice to the legacy of Chief Justice Harry Carrico, to the brilliant creations of Marshall and Jefferson and Madison and Hamilton, to the soul of our Constitution, than for the vastly important state courts in this country to become just another political branch. And so I end today with a challenge as well. Every politician has a choice to attempt to politicize the judiciary or to honor the importance and the separate and distinct role of judges. And every judge has a choice to exercise his or her First Amendment rights recognized in the White decision, to further obscure the differences between the role of judges and the role of others, or to forsake that personal freedom for a greater liberty, a lasting legacy for America and for Virginians of a land of equal justice, where the pendulum swings to and fro now and again, but swings steady, secure, balancing justice, nice, fine, and true. Thank you.
Well, based on what we've heard, I feel very comfortable having described members of this panel as exceptionally distinguished. I also noted, as I suspect all of you did, how different was the style of their arguments and how different was their approach substantively to the topic of judicial independence. And I wonder if that doesn't tell us that the topic was well chosen, is complicated, and very important. So we're going to try for a short while to explore some aspects of the subject of judicial independence through the means of questions. And I'm going to start by asking a question which I direct to Professor Powell, because Judge Starr touched on it, and it's this. Abraham Lincoln said concerning the questioning of a candidate for the bench, "We cannot ask what he will do on the court, and if we should, and if he should answer us, we should despise him for it." What is the proper subject of questioning of a judicial nominee, and where is the line beyond which we should not cross. In asking you this, Professor Powell, I think many of us have in mind the current controversy about the confirmation of Miguel Estrada and the criticism to which he's been subject for refusing to express substantive opinions and to provide internal memoranda, which he prepared in the course of his service in the Office of the Solicitor General.
Well, President Sullivan, it's obviously one of the vital questions of today. It seems to me that I'd like to invoke someone who Chief Justice Rehnquist reminded us was not necessarily always a reliable legal opinion maker, Aaron Burr. Burr once did draw a distinction that I think is of great importance. In discussing in correspondence the Republican attempt to repeal the Midnight Judges Act, Burr had been asked by his interlocutor if he thought that Congress had the constitutional power to repeal the Midnight Judges Act. And Burr, hemming and hawing a bit, wrote back that, well, I don't suppose there's any doubt about our power, but I must ask, would it be constitutionally moral? A difference he's drawing between what is constitutional, what may be the bare power of an entity under the Constitution, and what is moral, by which I take it Burr meant what is congruent with the overall and broader purposes and goals of the Constitution. I myself don't see easily how one can draw legal bounds around the Senate's questioning of a nominee and in the exercise of its advice and consent power, any more than I know how one can draw legal bounds around a president's consideration of what can be known about a nominee's views. On the other hand, I think quite clearly that presidents and their subordinates and senators and their investigators have an obligation, a moral obligation, if you will, to take into account the impact on our system of separated powers, one which depends vitally on the independence of the judiciary. They have an obligation to take into account the effect of their behavior on that system. And that should lead, I think, both members of the executive branch and members of Congress, and I think all of us, to have a different attitude than we sometimes display towards the question, an attitude that takes into account, as Professor White said, the long-term impact of what we do, not just the short-term consequences, but the long-term impact.
Professor White, would you have some comments on that question?
No.
Okay.
No, I'll leave the
All
federal.
right.
I just like to add a word on the internal memoranda. I think that is a very unfortunate effort on the part of members of the Senate and an intrusion into the deliberative process, which has historically been respected by the Congress. And indeed, a number of former Solicitors General, of whom I'm privileged to be one, who served under presidents of both parties, have urged in a letter to the senators that they cease and desist from seeking these kinds of deliberative documents, which have historically been viewed as very sensitive and for reasons grounded in executive privilege and the ability of the coordinate branches of government to function effectively. These kinds of documents have historically been very, very carefully treated. And I would hope that in this, as Professor White put it very powerfully, this vision of the pendulum, at least with respect to that, I hope that it would swing back toward greater respect for the coordinate branches.
Thank you. Let me ask a question which I direct to you, Professor White, and it's based on Virginia experience, very recent Virginia experience. Of course, here, the General Assembly elects and re-elects judges. And this session of the General Assembly, that is the one just concluded, featured some considerable controversy about the nature of that process. Perhaps one of the results of that controversy was the General Assembly passed a bill that provides for a judicial performance evaluation program which will embrace the distribution to lawyers and jurors who've appeared before the judge of evaluation forms that ask questions concerning courtesy, diligence, respect, fairness, equity, and other subjects such as that. And in addition, in the course of the debate, that resulted in the passage of this legislation, certain members of the General Assembly put their vote for this in the context of their conviction that judicial activism is a dangerous thing, and they're going to take that into consideration in the re-election process. So I'd ask you, what sort of grade would you give the General Assembly for that particular piece of legislation?
If my recollection is correct, the judiciary in Virginia was greatly involved in the idea of a judicial evaluation program. I believe I spoke here on it a couple years ago. And I think the idea of a judicial evaluation program gets an A in all books. The American Bar Association has published criteria that are appropriate for evaluating judges. The state judiciary was not intended to be a lifetime appointment, and there needs to be a review and evaluation. And those criteria that you began to read sounded very much to me like the criteria set out by the ABA, the kinds of things that judges are supposed to exercise: diligence to their job, temperament, collegiality, knowledge of the law. Then we get down to things like activism versus passivism. I've yet to see a judge go out on the street corner and ask people to file lawsuits. I mean, for the most part, judges are handling dockets, and they are perceived as active because citizens are bringing more and different kinds of controversies and dumping them in the laps of the courts. And the courts do not have the liberty of backing away from those. Certainly under some judicial principles of restraint and abstention they do, but for the most part courts are dealing with the controversies and settling the disputes that are brought before them. So when we get to things like activism or ideology, the three examples I gave that I think were used in the recent review here in Virginia of asking, trying to get into why a judge might think that a lesbian parent should have as significant of visitation rights as a non-lesbian parent. Those kind of things are, that's an F. It's lower than an F. Can we get lower than an F, Professor? It's an F minus, because it's not a part of the role of the judge, and it blurs the role of the legislative function and the judicial function, in my opinion. So as far as evaluations, I think that's excellent. 4 or 5 years ago, there were only 8 states, I think, and now more and more states are adding evaluations. The citizens deserve that information, but they deserve information that allow them to judge a judge by the right criteria, not by political criteria.
Professor Powell, any reactions to the... None?
We're
Judge
so
Starr?
easy.
All right. Well, let me pursue it a little further. That is the subject of selection of judges at the state level. Some states elect, some states appoint. In the end, is the process the most important thing, or are there other factors which need to be taken into account, which would more certainly assure the integrity of the judicial selection process? In other words, what's really critical, in your view, to the selection process in terms of producing the best possible judges who understand the meaning of judicial independence? Judge Starr, you want to start?
I have fundamental problems with the whole idea of the elected judiciary. I think Virginia's is a very intriguing compromise, giving a responsibility to the General Assembly. But the ongoing experiment, which is now, of course, a tradition in Jacksonian democracy of electing judges, I think should be of concern to people. It certainly was the vision of the founding generation at the federal level that should not be the case for reasons that we have been discussing today. And I think it's very difficult in that kind of setting, a politicized setting, to really concentrate on the characteristics that should be the enduring characteristics. If the pendulum is where Justice White, Professor White would suggest, that you are concentrating on the enduring characteristics of integrity and competence and professional excellence and temperament, fair-mindedness and capacity and so forth. And I think one useful way of looking at any method of selection is to what extent do those enduring or permanent values, what T.S. Eliot would call the permanent things, those kinds of enduring characteristics, to what extent do those become submerged in the process? And I'm fearful that we are moving in a very political age to a process where increasingly, including in the federal system, those enduring characteristics that really do separate distinguished judges from those who are not distinguished, those kinds of capacities that have long been lifted up by bench and bar as those that really genuinely count are being in fact ignored.
Professor Powell?
Well, there's no mystic overlord to whom a state must bow when it sets up its constitutional system. So if a state chooses, as my home state of North Carolina has for many years, to elect judges, then you can't call that properly in itself a violation of that state's constitutional structure. On the other hand, I think if you look historically about the institution of elected judges, which, as Judge Starr points out, comes from the Jacksonian period, I think that one thing you will see is that it was not meant or not understood at the time fundamentally to compromise what I called independence of position. It was a means of strengthening responsibility of judges in their proper manner to the people, not of weakening responsibility to the people. And I think in a different world, in the world that Professor White pointed out we live in, one might well conclude, I as a North Carolinian might conclude, that whether we meant it so originally or not, what we now have is something that does indeed compromise independence of position, and therefore compromises independence of thought, ultimately, and that therefore we need to rethink the very institution itself.
Professor White?
Well, I think the one thing I didn't get to talk about because of our time limits, which I guess answers your question as to what's most important in the process. Maybe I'm rewriting the question so I can throw this in.
Fair enough. It's been done before.
is the most important thing is an informed and educated public. Whether the public elects judges or retains judges, and a retention system, a Missouri plan system, is no safeguard against partisan politics. They keep deciding whether to call me justice or professor. It's living proof of that. I mean, I was in a retention system, and that is no safeguard. But whatever the public does, whether they elect the judges, whether they retain, or whether they elect the representatives or the executive who selects or retains, the public has to be fully informed and educated about this priceless principle of independence and how all of our lives would be much less free without it. So I think the most important part of the process is what I know Chief Justice Rehnquist has worked on throughout his tenure and the state court chief justices, and that is helping the public understand the role of the judiciary. So, and we all have an ambassadorial or an educational role to do in that. Once the public really grasp it, I mean, I think they'll do what the early Virginians did. I mean, the seventh reason that we formed this country was to get judges out from under the will of the king. People died so we could have judges who weren't subject to the will of the king. And once people reconnect with how important that is, my pendulum's going to be really secure.
What could a critic of the comments that you all have made in response to that question said what we've heard is the common position of members of the Guild on the subject of judicial independence, which is, according to these critics, essentially an undemocratic idea, therefore dangerous. And what we really need is much more judicial accountability. Could you all be, you would be, I think, criticized by people who take that point of view, given the responses you've given. Or am I being unfair to you?
I mean, you're absolutely right, but what that does is to ignore the many avenues of accountability that exist within the system. Obviously, decisional accountability is via appeal. Individual accountability, in my way of thinking, is via codes of judicial conducts and other ethical and just the legal profession's barometer that they're not going to put up with a judge who is not accountable to the law. But accountability is to the rule of law, not to an ideology or a party or the industry that got you on the bench, to my way of seeing it.
Well, I think that there is a role at times for the judges themselves. I'm going to pick up on what we just said to say we really are troubled by the behavior of this individual. I'm reminded of the circumstances of a sitting federal judge who was charged with a crime, who was acquitted, but who, on the strength of that same evidence, was reported by the Judicial Council of his circuit to the House of Representatives, that proceeded to consider the body of evidence seriously, to return articles of impeachment, and this individual was eventually convicted and removed from office. He sits in the House of Representatives these days, but this is a great country. But the point is, there were judges willing to step up, and I think that judges from time to time are going to be called upon to exercise that sort of unpleasant duty to say there is a problem here, and that we need to address the problem in a thoughtful and reasoned and professional way in accordance with law, as opposed to fits of pique and personal vendettas and the like. The kinds of things that have animated these kinds of issues in the past. So I think, being reminded of Justice Frankfurter's observation that the history of liberty is in no small measure the history of procedure, we can in fact identify thoughtful and reasoned procedures that help us to achieve greater accountability even in the federal system.
There's more than one way to imagine setting up a democratic system of government. And so if someone from a different set of premises wants to say, well, that's undemocratic, that may very well be irrefutable in itself. But as Chief Justice Rehnquist pointed out, we have a long tradition in which we have successfully maintained what I think most people would view as a humane government under law, working in our own premises, within our own tradition. And as I was trying to argue, our own tradition of judicial independence is one that understands judicial independence not as a means of freeing judges from their appropriate responsibility to the people, but rather a way of enabling them to act in responsibility to the people.
Ladies and gentlemen, I regret that our time has expired. And we are very lucky to have been here to observe and listen to these three panelists, I think. Don't you agree?
Great to be with you. I'm sneaking out.
Take care.
I'm going to sneak out right after the presentation.
Safe travels.
Thank you. Thank you, David. Yes, I think so.
I should tell you, as President Cooper did, that we will now have a short interval so that the setting here can be rearranged. And during that interval, if you would please, for security reasons, remain in your seats.
Good afternoon. Mr. Chief Justice, ladies and gentlemen, my name is John Jeffries. I'm the Dean of a law school a few miles up the road, and am particularly grateful to be invited to this remarkable occasion at the University of Richmond. It's my happy duty to present to you the man of the hour and of the last 42 years, Harvie Carrico. I could spend more time than the program allots to me recounting his virtues. It seems to me that one of the truly remarkable things about Harvie Carrico is the combination of forward-looking adaptability in matters of technology and management, with rock-solid adherence to traditional values for the profession of law. On the one hand, Chief Justice Carrico led the way in the electronic transformation of the court system and in the incorporation of new technology into the administration of justice, and in a host of pilot projects and judicial reform measures that earned him a reputation not just in Virginia but nationwide. And on the other hand, he has been uncompromising in insisting that changes in the delivery of legal services and in the technology of judicial and dispute resolution not be allowed to undermine or to dilute the professional responsibility of the lawyer. The Chief's commitment to the ideals of our profession is evident in an annual ceremony held in October where the newly admitted members of the Virginia State Bar take the oath of office. Many of you in this room will have the pleasure of participating in that ceremony one of these days, and for those of you who have not been present, it is a very attractive occasion. There are usually more than 1,000 people there. I think last time about 1,400. They are called by name and asked to stand, and they take the oath of office as lawyers of the Commonwealth of Virginia in a ceremony presided over with genial efficiency by Chief Justice Carrico. The deans and the others who come to move the admission of the bar members, John Pagan and I did it last fall, and Rod Smola will do it in October. We are given a little statement to read, and everybody reads the statement, and it gives instructions. You're supposed to rise when your name is called. You're supposed to remain standing. Please hold your applause, so forth. Well, after the instructions have been given 5 or 6 times, people pretty well know them, and it seems to me they become unnecessary. So the first time I had this honor, I was filling in for my dean, Bob Scott. Well, I made a little speech. It was a very small speech expressing pride and confidence in the graduates of my institution who were being admitted to the bar. And I strayed from the little text for perhaps 2 sentences, and I saw the chief begin to tilt his head and look at me, and it seemed to me the hand was going for the gavel, as if to say, I thought we had an agreement about this, John. So I brought it home in under 30 seconds, and the chief gave me a little nod, as just to say I just made it under the wire. He runs a tight ship. At the swearing-in ceremony, the chief administers the oath, and the applicant swears, I will faithfully, honestly, professionally, and courteously demean myself in the practice of law. Faithfully and honestly have been there for a long time. Professionally and courteously were added by Chief Justice Carrico, and they are a memento of his lifelong commitment to standards of civility, honesty, reliability, professionalism, decency in the practice of law. The words have unusual weight when they are followed, as they are in October, with a speech from the chief welcoming the new members to the bar. Here are a few of his words from last October. As members of the legal profession, you become active participants in a most essential public endeavor, the administration of justice. You also become officers of the court. In this role, you have the duty to guard the reputation and uphold the dignity of the legal profession, to promote respect for law, and to protect the integrity of the judiciary, which is the mainspring of our system of justice. You also have the responsibility to deal fairly and honestly with your clients and to conduct yourselves in accordance with the high standards of our profession. Hearing these words repeated by me here today does not capture the impact they had on that occasion. Delivered with gravity and conviction, the chief's challenge to the young lawyers was clear and meaningful. It had the quality in that setting of a kind of loving admonition, the remarks perhaps that a kindly grandfather might make to a grandchild of whom he expected much, but whom he was also willing to help. Chief, in the best and the fullest sense of the phrase, you set an example for those young lawyers, as you set an example for us all. Ladies and gentlemen, Harvie Carrico.
Thank you very much. Thank you, John, for that wonderful introduction. Professor White, as one who has had a serious decline in his finances recently, I was intrigued by your story of the judge who charged admission to his swearing-in ceremony. Now, it's a little late to do an admission charge, but how about an exit fee? It's been accepted almost unanimously, I think. I need volunteers, though, for doorkeepers, not to let anybody out who doesn't pay the exit fee. You know, I feel like I ought to pinch myself to make sure that this is really true, that this is really happening to me. I know it is, of course, but it's just something I never thought would ever happen to me. It is way beyond my expectations. I didn't set out to break records. I just did what I thought I was supposed to do. And I stuck around as long as I did because I loved what I was doing. It's been a wonderful life on the bench. The thing that has made it wonderful are the wonderful people that I've been associated with as members of my court, members of the bar. It's just been a glorious experience. And I can't tell you how much it means to me, sir, that the Chief Justice of the United States would come here when I'm being honored. You have had a high degree of feeling for the state courts. You're the first one to appoint a state judge to a standing committee of the Judicial Conference of the United States. And I think that was a great thing in recognition of the state courts. I was one of those that you first appointed. And I still appreciate it very much. I think I set a record for the longest service on the Federal State Jurisdiction Committee. Now, whether it's been broken since, I don't know. But I think I did. But I just want you to know, sir, that this is not only an honor to me, but an honor to Virginia to have you come down here for this purpose. Thank you very much. And I must thank the Bar Association of the City of Richmond and the University of Richmond for conceiving this meeting and putting it on in the beautiful way that they have. The Bar Association of the City of Richmond works for the best that there is in our profession. High standards of ethics and a devotion to professionalism. Bill Broadus, who I think represented the Bar Association, is a former law clerk of mine, and I'm very proud of him for what he has achieved. Now, the law school story you may not know. I did not attend the University of Richmond. But somewhere along the line, the school either adopted me or I adopted it. And I'd kind of like to have the adoption made official. Judge Dean Pagan. We've got some judges here to sign orders. Do you know any good lawyers we could get to prepare a petition? But really, it has been just the most marvelous thing to me to be associated with the Richmond Law School. They have been so kind to me. They've given me an honorary Doctor of Laws degree. They made me an honorary member of the McNeil Law Society. They have named the fall moot court competition for me and just have gone out of the way to be nice to me. And I just want you to know, you and Dr. Cooper, just how much it means to me to have that association and relationship. Dean Pagan appointed me chairman of the John Marshall Scholar Committee. We met it was just this past Tuesday, wasn't it? And we awarded 12 scholarships. And I undertake to call each one of those persons individually. And that is more fun than you can imagine, to get their reaction to knowing that they've gotten this scholarship. And that's one job I really enjoy. But I want to thank Dr. Cooper for coming and making the great remarks that he did. Chief Judge Wilkinson, you did a great job in introducing the chief, but you and I have a friendship that goes back a long ways, which I treasure highly, sir. And President Tim Sullivan, we've knocked around right much together. I swore you in as president of the College of William and Mary, and I think it must have done a pretty good job, because you've done a pretty good job as being president, and delighted to have you here. And I just thought the three participants on the panel was outstanding. It could not have been better. And I'm just so pleased that you would agree to come and share your views and your thoughts with us. And it was just a remarkable display. I must tell you that there is some regret in my having to retire, and I had to retire. I didn't have any choice. I got too old. Well, the state thought I was too old. Lynn and I didn't think so, but that didn't cut much ice. But I'm proud of the judiciary of Virginia. We have wonderful judges. We have a dedicated, loyal staff. We have a large caseload. Yet we are current in our docket. And we achieve that by one thing: cooperation. Cooperation of the members of the court and cooperation of the staff. I have been honored to have served as Chief Justice of a court of that caliber. And I owe a great debt to Governor Almond, who first appointed me to the court. But about the topic of today's discussion, I hope that from this meeting will come the strong message that it is absolutely essential to preserve the independence of the judiciary of this great nation. But what does independence mean in this context? Being independent means being honest in face of all temptation, being resistant to prejudice or sway, being courageous in mind and spirit, never fearing the consequences of a decision, never hesitating to do what is right, no matter how unpopular such a stand may be. It means being free financially, morally, and intellectually from every person and from every influence. Why would anyone want to change any of this? Who would want a judge who is lacking in any of these qualities? Who is not a person with the highest marks in integrity, impartiality, courage, and strength of conviction? Who wants a judge who would decide a case, not the way it should be decided, but the way a particular person or group with an axe to grind want it decided? Yet, take away judicial independence, and some or all of these consequences will surely follow. We might create a situation where a judge would approach each case having foremost in mind an apprehension of the personal consequences to him or her as a result of a decision. And we just cannot allow that sort of situation to develop. I have been on the bench for a long time, and it has been a wonderful experience. Made that way because until now, I have never felt any threat to my independence or any fear of what happened to me personally if I decided a given case in a certain way. Several recent instances, however, have caused me to wonder if there is not a storm gathering on the horizon that threatens to put the concept of judicial independence in serious jeopardy. And if that is true, it should alarm every person in this country. We have a strong judiciary in America. It may have its faults, but it is the best in the world. It has come this far because it has been independent and not the subservient handmaiden of the other branches of government. If it is to remain strong, it must retain its independence, else much will be lost. I cannot help but repeat what Chief Justice John Marshall said when he attended the Virginia Constitutional Convention of 1829-1830. Up for debate was a proposal that would have changed Virginia's method of judicial selection so that a judge's tenure in office would be at the pleasure of the legislature. Because of his concern that the proposal would compromise the independence of the judiciary, Marshall delayed his return to Washington to help defeat the proposal. Here's what he said at the convention. The judicial department comes home in its effects to every man's fireside. It passes on his property, his reputation, his life, his all. Is it not to the last degree important that a judge should be rendered perfectly and completely independent with nothing to control or influence him but God and his conscience? And then with the quotation that Professor White used, I have always thought from my earliest youth till now that the greatest scourge an angry heaven ever inflicted upon an ungrateful and sinning people was an ignorant, a corrupt, or a dependent judiciary. Will you draw down this curse upon Virginia? The answer must be, my friends, a loud and clear no. We must not draw down upon Virginia, or any other state in the land for that matter, the curse of a dependent judiciary. There is nothing to be gained. There's simply too much to lose. So I beg you to stay on the alert. Thank you for a wonderful day. I shall remember you always. God bless you.
Please be seated. I'm John Pagan, Dean of the University of Richmond School of Law. Justice Carrico has been a wonderful friend of our law school and an outstanding role model for our students. And to commemorate his many contributions to the law school, we commissioned a portrait of him by the very talented Richmond artist Loren Brazier, who's joined us on stage. And the painting will hang in our moot court room. As Justice Carrico mentioned, our moot court competition is named after him. And so I think it's very appropriate that we have that permanent reminder of his many contributions to T.C. Williams. And now I'd like to ask Justice Carrico's wife, Lynn Brackenridge, his daughter, Lucretia Carrico, and granddaughter, Ann Roberts, to unveil the portrait. Well, congratulations, Loren, for painting. I was just going to say she has painted a superb likeness of a truly great man. Well, that concludes our program. I'd like to congratulate the organizers for a stimulating and interesting afternoon. And I hope you'll join us at a reception sponsored by the law school, which will be held next door in the Maudlin Center. And as you go out of this room, people will point you in the direction. Thank you very much for coming. Good afternoon.